Veuillez vous asseoir, s'il vous plaît. Au nom de la Cour, j'aimerais vous souhaiter la bienvenue à cette audience publique au cours de laquelle nous allons rendre quelques arrêts. D'abord, permettez-moi de nous excuser pour ce retard. Nous avions juste quelques éléments à finaliser. Maître Diallo. Maître Diallo. Diallo, you said that the representative of APDF and not representative. Okay, thank you. Okay. L'affaire donc Association pour le progrès et la défense des droits des femmes maliennes et Institute for Human Rights and Development in Africa contre la République de Mali, requête numéro 046-2016. Le délibéré donc de cette affaire sera lu par l'honorable juge Mengue.
Merci, Monsieur le Président. La Cour, composée de Sylvain Auré, président, Ben Kioko, vice-président, Gérard Ninyengeko, El Adjisse, Rafa Ben Achou, Angelo Matousse, Cham Undo, épouse Mengue, Suzanne, Marie-Thérèse Mukamuliza, Tujilan, Tizumila, Chafika Ben Saoula, tous juges, et Robert Eno, greffier. En l'affaire Association pour le progrès et la défense des droits des femmes, APDF, et Institute for Human Rights and Development in Africa, IHRDA, représenté contre la République du Mali. Les parties sont les suivantes. L'Association pour le progrès et la défense des droits des femmes maliennes, APDF, se présente comme une association malienne jouissant du statut d'observateur auprès de la Commission africaine des droits de l'homme et des peuples, si après la Commission, elle a pour mission de favoriser le regroupement des femmes pour la défense de leurs droits et intérêts contre toute forme de violence et de discrimination. L'Institute for Human Rights and Development in Africa, IHRDA, se présente de son côté comme une organisation non gouvernementale panafricaine basée à Banjul en Gambie. Elle a pour mission d'assister les victimes de violations des droits de l'homme en quête de la justice en utilisant des instruments de droits de l'homme à l'échelle nationale, africaine et internationale. Elle déclare également avoir le statut d'observateur auprès de la Commission. Ces deux entités ci-après désignées sont désignés les requérants. L'État défendeur est la République du Mali, devenue partie à la Charte africaine des droits de l'homme et des peuples, ci-après la Charte et à plusieurs instruments internationaux. L'objet de la requête. Dans le but de moderniser sa législation en la rendant conforme à l'évolution du droit international des droits de l'homme, le gouvernement du Mali a lancé, courant 1998, une vaste opération de codification du droit des personnes et de la famille. Ce projet, soumis à de larges consultations populaires, a reçu des contributions d'experts avant l'élaboration de la loi portant code de la famille des personnes, code des personnes et de la famille, ci-après nommé le code de la famille, qui fut adopté par l'Assemblée nationale du Mali le 3 août 2009. La loi, bien accueillie par une grande partie de la population, ainsi que les organisations de défense des droits de l'homme, n'a pu être promulguée en raison d'un vaste mouvement de protestation des organisations islamiques. Soumise à une deuxième lecture, la loi contestée a finalement donné lieu à l'élaboration d'un code de la famille et des personnes qui a été adopté le 2 décembre 2011 par l'Assemblée nationale et promulgué le 30 décembre 2011 par le chef de l'État. Les requérants estiment que la loi telle que promulguée viole plusieurs dispositions des instruments internationaux des droits de l'homme ratifiés par l'État défendeur. Voici les violations alléguées. Le requérant allègue les violations suivantes: violation de l'âge minimal du mariage pour les filles, violation du droit de consentir au mariage, violation du droit à la succession, violation de l'obligation d'éliminer des pratiques ou attitudes traditionnelles qui nuisent aux droits de la femme et de l'enfant. Voici les mesures demandées par les parties. Les requérants demandent à la Cour de condamner l'État défendeur, le Mali, à modifier son code de la famille des personnes en ramenant l'âge minimal de mariage des filles à 18 ans accompli, et éliminer les dispositions du code de la famille qui permettent les dispenses d'âge, introduire un programme de sensibilisation de la population sur les dangers du mariage précoce, modifier les articles 283 et 287 du code de la famille pour exiger les mêmes conditions de consentement pour les mariages contractés devant un ministre du culte, modifier l'article 287 pour imposer les mêmes peines à un ministre du culte qui procède à un mariage sans avoir vérifié le consentement des époux. Ajouter à la section 2 intitulée de la célébration devant le ministre du culte une disposition qui oblige ce dernier de vérifier le consentement des époux. Insérer dans le code de la famille une disposition qui exige une procuration notariée de l'homme et de la femme lorsque ceux-ci ne sont pas présents lors d'un mariage religieux. Traduire et disséminer le code de la famille dans les langues accessibles aux officiers du culte. Introduire un programme de formation pour les ministres du culte sur la procédure de célébration du mariage. Introduire un programme de sensibilisation et d'éducation de la population à l'usage des dispositions du code de la famille qui assure le partage égal de l'homme et de la femme en matière de succession. Développer une stratégie pour éliminer la pratique du partage inégale entre l'homme et la femme en matière de succession, développer un programme pour assurer l'accès de la population rurale au service d'un notaire. Enfin, développer un programme de sensibilisation de la population sur l'usage et les dispositions du Code de la famille qui assure le partage successoral égal entre l'enfant légitime et l'enfant naturel. Dans sa réponse, l'État défendeur soulève deux exceptions préliminaires, l'une tirée de l'incompétence de la Cour et l'autre de l'irrecevabilité pour non-respect du dépôt de la requête dans un délai raisonnable, conformément à l'article 6 de la Charte, et puis la Cour de faire droit aux exceptions soulevées, se déclarer incompétente dès lors que la demande des requérants renvoie plus à des questions de sensibilisation, de vulgarisation et d'harmonisation des textes nationaux avec la Charte africaine des droits de l'homme et des peuples, plutôt qu'à des problèmes d'application et d'interprétation de la Charte et des autres conventions qui n'existent ni techniquement ni réellement et n'ont jamais été prouvées dans la pratique judiciaire au Mali. S'agissant du fond, l'État défendeur demande à la Cour de rejeter purement et simplement la requête comme étant non fondée. Sur la compétence de la Cour, au terme de l'article 39 du règlement, la Cour procède à un examen préliminaire de sa compétence. L'exception d'incompétence matérielle de la Cour. S'agissant de cette exception, la Cour fait observer que sa compétence matérielle est fondée sur l'article 3.1 du protocole et que dans le cas d'espèce, la violation des droits allégués est en rapport avec les droits de l'homme garantis par la Charte et d'autres instruments ratifiés par la République du Mali. En conséquence, la Cour déclare que sa compétence matérielle est établie et rejette cette exception. Sur les autres aspects de la compétence, la Cour observe que sa compétence personnelle, temporelle et territoriale est établie et n'est pas contestée par les parties. Au vu de l'ensemble de ces considérations, la Cour conclut qu'elle est compétente pour connaître de la présente affaire. Maintenant, sur la recevabilité, en vertu de l'article 6 du protocole, la Cour statue sur la recevabilité des requêtes en tenant compte des dispositions énoncées à l'article 56 de la Charte. Alors que certaines de ces conditions ne sont pas en discussion entre les parties, l'État défendeur a soulevé deux exceptions, l'une en rapport avec l'épuisement des voies de recours internes et l'autre concernant le délai de saisine de la Cour. Condition d'abord en discussion entre les parties. L'exception d'irrecevabilité tirée du non-épuisement des voies de recours internes. Sur cette exception, la Cour observe que le seul recours que les requérants pouvaient exercer est le recours en inconstitutionnalité de la loi contestée. L'article 85 de la Constitution malienne dispose que la Cour constitutionnelle est juge de la constitutionnalité des lois et elle garantit les droits fondamentaux de la personne humaine et les libertés publiques. L'article 88 de la même Constitution dispose que les lois organiques sont soumises par le Premier ministre à la Cour constitutionnelle avant leur promulgation. Les autres catégories de lois, avant leur promulgation, peuvent être déférées à la Cour constitutionnelle, soit par le président de la République, soit par le Premier ministre, soit par le règlement repris à l'Assemblée nationale. La Cour n'est disponible pour les requérants. En conséquence, la Cour rejette l'exception d'irrecevabilité pour non-épuisement des voies de recours internes soulevées par l'État défendeur. Maintenant, sur l'exception d'irrecevabilité tirée du non-respect d'un délai raisonnable, la Cour estime que la Cour est d'avis que dans la présente affaire où aucun recours n'était ouvert au requérant au niveau interne, la date de départ du délai de saisine est celle de la prise de connaissance des requérants de la loi contestée. La question ici est de savoir si le délai de 4 ans, 6 mois et 24 jours après lequel les requérants ont saisi la Cour, c'est-à-dire entre le 30 décembre 2011, date de promulgation de la loi contestée, et le 26 juillet 2016, date de saisine de la Cour, est un délai raisonnable au sens de l'article 56 de la Charte. Dans ses arrêts antérieurs, la Cour a établi que le caractère raisonnable du délai de sa saisine dépend des circonstances particulières de chaque affaire et doit être apprécié au cas par cas. Dans la présente affaire, pour déterminer si le délai de saisine de la Cour est raisonnable, il convient de prendre en considération 2 éléments importants. Premièrement, le fait que les référents ont besoin du temps pour vérifier la conformité de la nouvelle loi avec les instruments internationaux auxquels l'État défendeur est parti. Deuxièmement, compte tenu du climat de peur, des intimidations et menaces qui caractérisaient la période postérieure à l'adoption du premier Code de la famille le 3 août 2009, il est raisonnable que les requérants aient été affectés par la situation, le pays s'étant retrouvé dans une situation de crise exceptionnelle, avec un vaste mouvement de protestation des forces religieuses, selon l'État défendeur lui-même, selon l'État défendeur lui-même, pouvait être fatal pour la paix, la cohabitation et la cohésion sociale. De ce qui précède, la Cour rejette l'exception d'irrecevabilité de la requête tirée du non-respect d'un délai raisonnable dans la soumission de la requête devant elle. Sur les conditions non en discussion entre les parties, conditions de recevabilité, la Cour constate que le respect des points 1, 2, 3 et 4 de l'article 40 du règlement n'est pas contesté. À la lumière de ce qui précède, la Cour conclut que la présente requête est recevable. Maintenant, sur le fond de la requête, il y a d'abord la violation alléguée relative à l'âge minimal du mariage. Les requérants relèvent que l'article 281 de la loi contestée portant code de la famille des personnes et de la famille fixe l'âge minimum pour contracter mariage à 18 ans pour le garçon et 16 ans pour la fille. L'article 2 de la 4B définit l'enfant comme tout être humain âgé de moins de 18 ans. L'article 4.1 de la même charte énonce dans toute action concernant un enfant entreprise par une quelconque personne ou autorité, l'intérêt supérieur de l'enfant sera la considération primordiale. L'article 21 de cette charte dispose également que les États partis doivent prendre toutes les mesures appropriées pour abolir les coutumes et pratiques négatives, culturelles et sociales, ainsi que celles qui constituent une discrimination à l'égard de certains enfants pour des raisons de sexe ou autres raisons. L'article 6B du protocole de Maputo stipule que les États veillent à ce que l'homme et la femme jouissent des droits égaux et soient considérés comme des partenaires égaux dans le mariage. À cet égard, les États adoptent des mesures législatives appropriées pour garantir que l'âge minimum de mariage est de 18 ans. La Cour note que toutes les dispositions précitées mettent l'accent sur l'obligation qui incombe à l'État de prendre toutes les mesures appropriées pour abolir les coutumes et pratiques négatives et les pratiques discriminatoires à l'égard de certains enfants pour des raisons de sexe, notamment des mesures pour garantir l'âge minimum de mariage à 18 ans. La Cour note également que l'État défendeur, comme indiqué dans les paragraphes 64-65 ci-dessus, admet de manière implicite que le présent Code de la famille adopté face à une situation de cas de force majeure n'est pas conforme aux exigences du droit international. La Cour note par ailleurs que l'article 281 du Code de la famille attaqué fixe effectivement l'âge de mariage à 18 ans pour l'homme et 16 ans pour la femme. En outre, l'article inclut aussi une possibilité pour l'autorité administrative d'accorder une dispense d'âge de 15 ans pour des motifs graves. La Cour conclut qu'il incombe à l'État défendeur de garantir le respect de l'âge minimum du mariage, à savoir 18 ans, et le droit à la non-discrimination. Que ne l'ayant pas fait, l'État défendeur a violé les articles 6 du protocole de Maputo. Violation du droit du consentement au mariage. L'article 6 du protocole de Maputo dispose que les États veillent à ce que l'homme et la femme jouissent des droits égaux et soient considérés comme des partenaires égaux dans le mariage. À cet égard, les États adoptent des mesures législatives appropriées pour garantir qu'aucun mariage n'est conclu sans le plein et libre consentement des deux. La Cour observe que le protocole de Maputo, dans ses articles 2, 1 et 6, et la Convention sur l'élimination de toutes les formes de discrimination à l'égard des femmes, dans ses articles 10 et 16, énonce le principe de libre consentement au mariage. La Cour note qu'en dépit du fait que ces instruments soient ratifiés par le Mali, le Code de la famille en vigueur prévoit l'application de la loi islamique, article 751, et donne compétence au ministre du culte pour célébrer les mariages, mais n'exige pas d'eux la vérification du libre consentement des époux. De plus, alors que des sanctions sont prévues à l'égard de l'officier d'état civil en cas de non-vérification du consentement des futurs époux, aucune sanction n'est prévue pour un ministre du culte qui ne respecte pas cette obligation. La vérification du consentement donné oralement et en personne est exigée devant l'officier d'état civil en application de l'article 287 du Code de la famille, alors qu'elle ne l'est pas concernant le ministre du culte. La Cour relève également que les conditions que doit remplir un officier d'état civil pour célébrer un mariage hors la présence des époux sont la déposition par la partie empêchée d'un acte dressé par l'officier d'état civil de sa résidence, condition non exigée dans le mariage célébré par un ministre du culte. La Cour fait remarquer que la manière dont se déroule le mariage religieux au Mali présente des risques graves pouvant donner lieu à des mariages forcés et constitue une pérennisation des pratiques traditionnelles qui violent les normes internationales, qui consacrent les conditions précises quant à l'âge et au consentement des époux pour qu'un mariage soit valide. La Cour relève que dans la procédure de célébration du mariage, la loi contestée permet l'application des droits religieux et coutumiers concernant le mariage, le consentement au mariage. Elle ménage en outre des régimes différents selon que le mariage est célébré par l'officier d'état civil ou par le ministre du culte, ce qui constitue une violation des instruments internationaux, à savoir le protocole de Maputo, la CEDEF et la CADB. Autre violation, violation du droit à la succession pour les femmes et les enfants naturels. S'agissant de cette violation alléguée, la Cour estime que l'article 21 du protocole de Maputo dispose: la veuve a le droit à une part équitable dans l'héritage des biens de son conjoint et que, tout comme les hommes, les femmes ont le droit d'hériter des biens de leurs parents en parts équitables. En ce qui concerne l'enfant, l'article 3 de la Charte des droits de l'enfant, ci-dessus, reconnaît à l'enfant tous les droits et libertés et proscrit toute forme de discrimination, quel qu'en soit le fondement. La Charte des droits de l'enfant ne fait donc aucune discrimination entre les enfants et tous ont droit à la succession. La Cour observe qu'il ressort des instruments précités qu'en matière de succession, une importante place est accordée aux droits de la femme et de l'enfant, la veuve et l'enfant naturel ayant les mêmes droits que tous les autres. Les instruments garantissant une égalité de traitement pour les femmes et pour les enfants sans distinction aucune. La Cour note que dans la présente affaire, le Code de la famille applicable au Mali consacre le droit religieux et coutumier comme le régime applicable en l'absence de tout autre régime de droit ou d'un écrit authentifié par les services d'un notaire. L'article 751 du Code de la famille prévoit que l'héritage est dévolu selon les règles du droit religieux ou selon les dispositions du présent livre. La Cour relève que le droit musulman actuellement applicable dans le territoire de l'État défendeur en matière de succession ainsi que les pratiques coutumières ne sont pas conformes aux instruments ratifiés par ce dernier. La Cour conclut que l'État défendeur a donc violé les textes visés. La violation suivante, c'est la violation de l'obligation d'éliminer les pratiques ou attitudes traditionnelles qui nuisent aux droits de la femme et de l'enfant. S'agissant de cette violation, l'article 2 du protocole de Maputo dispose que les États s'engagent à modifier les schémas et modèles de comportement socio-culturel de la femme et de l'homme pour l'éducation du public par le biais des stratégies d'information, d'éducation, de communication, en vue de parvenir à l'élimination de toutes les pratiques culturelles et traditionnelles néfastes et de toutes autres pratiques fondées sur l'idée d'infériorité ou de supériorité de l'un ou l'autre sexe, ou sur les rôles stéréotypés de la femme et de l'homme. L'article 5A de la CEDEF dispose: les États parties prennent toutes les mesures appropriées pour modifier les schémas et modèles de comportement socio-culturel de l'homme et de la femme en vue de parvenir à l'élimination des préjugés sur des pratiques coutumières ou de tout autre type qui sont fondées sur l'idée de l'infériorité ou la supériorité de l'un ou l'autre sexe, d'un rôle stéréotypé des hommes et des femmes. Les articles 16 de la Convention, l'article 16.1 de la Convention sur l'élimination de toutes les formes de discrimination à l'égard de la femme stipule que les États parties prennent toutes les mesures appropriées pour éliminer la discrimination à l'égard des femmes dans toutes les questions découlant du mariage et dans les rapports familiaux, et en particulier assure, sur la base de l'égalité de l'homme et de la femme, le même droit de contracter mariage, le même droit de choisir librement son conjoint et de ne contracter mariage que de son libre et plein consentement. La Cour ayant déjà établi la violation des dispositions relatives à l'âge minimum du mariage, au droit au consentement au mariage et au droit à la succession pour les femmes et les enfants naturels, la Cour conclut que l'État défendeur, en adoptant le code de la famille concerné et en y maintenant des pratiques discriminatoires qui nuisent aux droits de la femme et de l'enfant, a violé ses engagements internationaux. De ce qui précède, la Cour constate la violation par l'État défendeur, c'est-à-dire le Mali, des articles 2 du protocole de Maputo, 5 de la CEDEF et 21 de la 4B. Maintenant sur les réparations. Dans la requête, il est demandé à la Cour d'ordonner des mesures énumérées au paragraphe précédent, 16, au paragraphe 16 que nous avons lu au début, qui vise l'amendement de la législation d'une part et en adoptant des mesures visant l'information, l'éducation, la sensibilisation des populations. Concernant les mesures demandées par les requérants et visant l'amendement de la législation nationale, la Cour considère en effet que l'État défendeur doit modifier sa législation pour la rendre conforme aux dispositions des instruments internationaux applicables. S'agissant des mesures demandées au paragraphe 16, lu au début, la Cour note que l'article 25 de la Charte stipule que les États partis ont le devoir de promouvoir et d'assurer par l'enseignement, l'éducation et la diffusion le respect des droits et libertés contenus dans la Charte et de prendre des mesures en vue de veiller à ce que ces libertés et droits soient compris, de même que les obligations et devoirs correspondants. L'État défendeur doit se conformer aux engagements pris en vertu de l'article 25 de la Charte. Dans la présente affaire, s'agissant des frais de procédure, la Cour note que l'article 30 du règlement dispose qu'à moins que la Cour n'en décide autrement, chaque partie supporte les frais de procédure. Compte tenu des circonstances de cette affaire, la Cour décide que chaque partie prend en charge ses frais de procédure. Par ces motifs, la Cour, à l'unanimité, rejette l'exception d'incompétence, déclare qu'elle est compétente, rejette les exceptions d'irrecevabilité, déclare la requête recevable, dit que l'État défendeur a violé l'article 6 du protocole de Maputo et les articles 2 et 21 de la Charte africaine des droits et bien-être de l'enfant relatif à l'âge minimum du mariage. Dit que l'État défendeur a violé l'article 6 du protocole de Maputo et l'article 16 de la Convention, la CEDEF, relatif au droit de consentir au mariage. Dit que l'État défendeur a violé les articles 21, 1 et 2 du protocole de Maputo et 3, 4 de la Charte africaine des droits et bien-être de l'enfant relatif au droit à la succession pour les femmes et les enfants naturels. Dit que l'État défendeur a violé l'article 2 du protocole de Maputo, les articles 1 et 21 de la Charte africaine des droits et bien-être de l'enfant article 5 de la Convention de la CEDEF portant sur l'élimination des pratiques ou attitudes traditionnelles religieuses qui nuisent aux droits de la femme et de l'enfant. Dit en conséquence que l'État défendeur a violé l'article 2 du protocole de Maputo, les articles 3 et 4 de la Charte africaine des droits et bien-être de l'enfant et l'article 16.1 de la Convention sur la CEDEF relatif au droit à la non-discrimination de la femme et de l'enfant. Ordonne à l'État défendeur de modifier la loi contestée en l'harmonisant avec les instruments internationaux et de prendre des dispositions utiles afin de mettre fin aux violations constatées. Dit que la constatation des violations ci-dessus constitue en soi une forme de réparation pour les requérants. Ordonne à l'État défendeur de se conformer à ses engagements en vertu de l'article 25 de la Charte concernant l'information, l'enseignement, l'éducation et la sensibilisation des populations. Ordonne à l'État défendeur de lui soumettre un rapport sur les mesures prises conformément aux paragraphes 10 et 12 dans un délai raisonnable qui dans tous les cas n'excède pas 2 ans à compter de la date du présent arrêt. Enfin, décide que chaque partie supporte ses frais. Fait à Arusha, ce 11e jour du mois de mai de l'an 2018, en français et en anglais, le texte français faisant foi.
Ainsi, on a décidé la Cour. Merci, honorable juge Mengue. Decision in the matter of Thobias Mangara Mango and Shukrani Masegenya Mango versus United Republic of Tanzania, application number 005/2015. The representatives, can you identify yourself for this matter, but also it will be valid for the other matters that will follow, since it's the same representative, I suppose. Yes.
For the applicant, Mr. François Godbout, assisted by Mr. Nelson Ndeki.
I am very Kasimlai, Principal State Attorney, representing the respondent in this application.
We are now reading the judgment. The court composed of the same bench previously listed in the matter of Thobias Mangara Mango and Shukurani Masegenya Mango, represented by Advocate Donald Deya, Pan-African Lawyers Union Council, versus United Republic of Tanzania, represented by Mrs. Sarah Mwaipopo, Acting Deputy Attorney General, Director, Division Constitutional Affairs and Human Rights Attorney General Chambers, and others. After deliberation, delivers the following judgment. The parties: Mr. Thobias Mangara Mango and Mr. Shukurani Mango, after referred to as first applicant and second applicant respectively, above citizens of the United Republic of Tanzania. The respondent state, namely the United Republic of Tanzania, became a party to the African Charter on Human and People's Rights on 21st October 1986, and also became a party to the Protocol of the African Charter on Human and People's Rights on the establishment of an African Court on Human and People's Rights on 10 February 2006. Furthermore, the respondent state deposited the declaration prescribed under Article 34.6 of the Protocol on 29 March 2010. Subject of the application, facts of the matter. The court was seized on the application on 11 February 2015. In the application, they alleged violation of their rights following their arrest, detention, and the manner in which the various cases were treated before the domestic courts of the respondent state. According to the application, on 3 July 1999, at about 8:30 a.m., two individuals struck at gunpoint the Zaid Bureau de Change located at Mwanza Hotel and stole large sums of money and traveler's check. The only witness to the robbery was Mrs. Fatuma Said, who worked as a cashier at this Bureau de Change. A police investigation was mounted, at the end of which 4 persons were arrested, among whom were the second applicant, who was arrested on 3 July 1999, and the first applicant, who was arrested on 4 July 1999. They were charged on 5 July 1999 with the offense of armed robbery, contrary to Section 285 and 286 of the Tanzanian Penal Code. Following the trial before the District Court of Mwanza in criminal case number 672 of 1999, the applicants were convicted and sentenced on 7 May 2004 to a term of 30 years imprisonment, each in criminal case number 672 of 1999. The applicants appealed the conviction and sentences to the High Court of Tanzania in criminal appeal number 2002-01 of 2004. The appeal was dismissed in its entirety by the High Court of Tanzania on 31 October 2005 on the basis that the sentence of 30 years imprisonment was lawful. The applicants further appealed to the Court of Appeal of Tanzania, sitting at Mwanza, in criminal appeal number 27 of 2006, and this appeal was also dismissed in its entirety on 12 May 2010. The Court of Appeal found that there was no error in the findings of the District Court and High Court on the substantive matters under appeal, and that the appeal lacked merit. The applicants then filed an application for review at the Court of Appeal in criminal application number 8 of 2010, but this was dismissed on 18 February 2013 on the basis that it showed no ground that raised the need for a review of the Court of Appeal's judgment in criminal appeal number 27 of 2006. The applicants claim that they subsequently filed on 17 June 2013 a constitutional petition at the High Court at Mwanza alleging violation of the human rights under the Basic Rights and Duties Enforcement Act. They claim that the constitutional petition was endorsed with the stamp of the District Registrar of the High Court on 17 June 2013. The applicants allege that following a considerable period of inquiry about the constitutional petition, it was returned to them by the Registrar of the High Court without an official letter. They allege that they were verbally instructed to direct their petition to the Court of Appeal. Alleged violation. The applicants outlined several complaints in relation to the manner in which they were detained by the respondent state's police authorities and tried and convicted by the respondent state's judicial authorities. They claimed that the principle of law and practice governing the matter of visual identification were neither met nor considered by the trial court. They were not represented by counsel. Were denied medical treatment and overstayed in police custody. They were denied a chance to be heard when the presiding magistrate was changed. no actual weapon was discovered or tendered in court to support the charge of armed robbery, and the owner of the Bureau de Change mentioned on the charge sheet was never called before the court to testify. The trial proceeded, despite them being denied some witness statements and some being provided to them after undue delays. The judgments of the trial court, first and second appellate courts, were defective due to the contradiction between the evidence of prosecution witness 2 and prosecution witness 3. The trial court tried the case and to its finality without considering or according weight to the written submissions. The High Court concluded the appeal by relying on misapprehension or misdirected evidence. The Court of Appeal relied on misconceived findings to convict them. Their constitutional petition was irregularly rejected and returned to them unprocedurally with no official letter. The application for review at the Court of Appeal was dismissed on grounds that it should have been raised in an appeal. The sentence meted against them following their conviction is contrary to Section 285 and 286 to the Penal Code of Tanzania, as this sentence did not exist at the time the offense was committed and it was harsh. They have suffered irreparable damage and inhuman treatment due to the violation of their human rights. In the application, the applicants allege violation of the human rights under Article 1, 2, 3, 5, 6, 7, 8, and 10 of the Universal Declaration of Human Rights, Article 3, 7, 72, 19, and 28 of the Charter, Article 107A, and so on of the Constitution of the United Republic of Tanzania, Article 6 of the European Convention of Human Rights, Article 8 of the American Convention on Human Rights, and Section 285 and 286 of the Penal Code of the United Republic of Tanzania regarding the illegal sentencing to 30 years imprisonment. Prayers of the parties. In the reply, the applicant reiterated their prayers in the application as follows. A declaration that the respondent state has violated the applicant's right granted under the African Charter, in particular Article 1 and 7. A declaration that the respondent state violated Article 2, 3, 5, 7, and 19 of the Charter and Article 1, 2, 5, 6, 7, 8, and 10 of the Universal Declaration of Human Rights at various stages of the trial process. A declaration that Section 142 of the Evidence Act is incompatible with international standards of the right to a fair trial. Another, that the respondent state takes immediate steps to remedy the violations in order for reparations, any other orders or remedies that this honorable court shall deem fit. In the response to the application, with regard to the court's jurisdiction and admissibility of the application, the respondent state praised the court to rule as follows: that the applicant has not evoked the jurisdiction of the honorable court, that the application be dismissed as it has not met the admissibility requirements stipulated under Rule 45 of the Rules of the Court, that the application be dismissed as it has not met the admissibility requirements stipulated under Rule 46 of the Rules of Court, that the application be dismissed in accordance to Rule 38 of the Rules of Court. With regard to the merits of the application, the respondent state praised the court for an order that it has not violated Article 1, 2, 6, and 7 of the United Nations Declaration of Human Rights and Article 3, 7, 10, 19, and 28 of the Charter. The respondent state further praised that reparations be denied to the applicants, they continue serving their sentence, and the application be dismissed in its entirety. Jurisdiction. In accordance with Rule 39(1) of the rules, the court shall conduct, and I quote, the court shall conduct preliminary examination of its jurisdiction. The respondent state raised only one objection on the material jurisdiction of the court. Objection on material jurisdiction of the court. Pursuant to Article 3.1 of the Protocol and Rule 26.1a of the Rules of the Court, The material jurisdiction of the court extends to, I quote, all cases and disputes submitted to it concerning the interpretation and application of the Charter, the Protocol, and other relevant human rights instruments ratified by the state concerned. This court reiterates its position as affirmed in Ernest Mitwengi versus Republic of Malawi, that it is not an appellate court with respect to decisions rendered by national courts. However, as it underscored in its judgment of 20 November 2015 in Alex Toma versus United Republic of Tanzania, and reaffirmed in its judgment of 3 June 1916 in Mohamed Abubakari versus United Republic of Tanzania, this situation does not preclude it from examining whether the procedures before national courts are in accordance with international standards set out in the Charter and other applicable human rights instruments to which the respondent state is a party. Consequently, the court rejects the respondent state's objection that the court is acting in the extant matter as an appellate court. Furthermore, regarding its material jurisdiction, the court notes that since the applicant alleges violation of provisions of some of the international instruments to which the respondent state is a party, it has material jurisdiction in accordance with Article 3(1) of the Protocol. The court notes that while the Universal Declaration of Human Rights is not an international human rights instrument that is subject to ratification by states, it has previously held that in the matter of Anude Ocheng Anude versus Tanzania, that the declaration has been recognized as forming part of the customary international law. As such, the court is adjourned to interpret and apply it. The applicant has also invoked the American Convention on Human Rights, the Convention for the Protection of Human Rights and Fundamental Freedoms, the respondent state's Constitution and Penal Code. In accordance with Article 3(1) of the Protocol, the court finds that it cannot establish violation based on the Constitution and Penal Code of the respondent states, which are national laws. The same applies to the American Convention on Human Rights and the European Convention on Fundamental Rights and Freedoms, to which the respondent state is not and cannot be a party. The court consequently finds that it has material jurisdiction over the application. Other aspect of jurisdiction, the court notes that its personal, temporal, and territorial jurisdiction has not been contested by the respondent state, and nothing in the record indicates that the court does not have jurisdiction. From the foregoing, the court finds that it has jurisdiction to hear the case. Admissibility of the application. First, condition of admissibility in contention between the parties. While some of the above conditions are not in contention between the parties, the respondent states raised 2 objections regarding exhaustion of local remedies and the time frame for seizure of the court. Objection based on the ground of non-exhaustion of local remedies. Any application before the court must comply with the requirement of the exhaustion of local remedies. However, in Alex Toma versus Tanzania, the court also held that the applicant was not required to exhaust domestic remedies in respect of alleged violations of fair trial rights which were occasioned in the course of his trial and appeals in the domestic courts. In the extant case, the court notes that allegations relating to the denial of legal assistance, prolonged detention in police custody, and illegality and harshness of the sentence imposed on the applicants constitute part of the bundle of rights and guarantees related to a fair trial, which were not required to have been specifically raised at the domestic level. The court consequently holds that the applicants are deemed to have exhausted the local remedies with respect to these claims. Concerning the filing of a constitutional petition regarding the violation of the applicant's rights, the court has already stated that this remedy in the Tanzanian judicial system is an extraordinary remedy that the applicants are not required to exhaust prior to seizing this court. In sum, The court therefore finds that the applicants have exhausted local remedies with respect to all their claims. Accordingly, the court dismisses the respondent state's objection to admissibility of the application for non-exhaustion of local remedies. Objection based on the ground of not filing the application within a reasonable time. The court notes that Rule 46 of the rules and Article 56(6) of the Charter that do not specify any period within which applicants should seize the court. Rather, this provision speaks of filing of the application within a reasonable time from the date when local remedies were exhausted or any other date as determined by the court. The court notes that local remedies were exhausted when the Court of Appeal dismissed the applicant's appeal on 12 May 2010. Therefore, this is the date from which time should be reckoned regarding the assessment of reasonableness of time as envisaged in Rule 46 of the rules. The court notes that the application was filed 4 years, 8 months, and 30 days after local remedies were exhausted. As the court has previously held, the computation of reasonableness of time, I quote, depends on the circumstances of each case and must be assessed on a case-by-case basis. The court considers in this regard that the applicants being incarcerated, they may not have been aware of the existence of the court or how to approach it, particularly since the respondent state had filed the declaration under Article 34(6) less than 2 months prior to when local remedies were exhausted. They should also not be penalized for attempting to use an extraordinary remedy, that is, the application for review of the Court of Appeal judgment, which was dismissed on 18 February 2013. The court finds that this factor constitutes sufficient justification as to why the applicant filed the application 4 years, 8 months, and 30 days after local remedies were exhausted. For these reasons, the court finds that the application has been filed within a reasonable time as envisaged under Article Rule 46 of the rules. The court therefore overrules this preliminary objection on admissibility. Conditions of admissibility not in contention between the parties. The condition regarding the identity of the applicant, the application compatibility with the Constitutive Act of the African Union, the language used in the application, the nature of evidence, and the principle that an application must not raise any matter already determined in accordance with the principle of the United Nations Charter, the Constitutive Act of the African Union, the provision of the Charter, or any other legal instrument of the African Union are not in contention between the parties. The court also notes that nothing in the record suggests that these conditions have not been met in the instant case. The court therefore ought that the requirements under those provisions are fulfilled. In light of the foregoing, the court finds that the instant application fulfilled all admissibility requirements in terms of Article 56 of the Charter and Rule 40 of the rules, and accordingly declares the same admissible. The merits. Alleged violation of the right to a fair trial. First, allegation relating to the applicant's identification. On the issue of visual identification, this court notes that the Court of Appeal observed that the identification by a single witness must be absolutely watertight to justify a conviction. The court notes that the Court of Appeal also considered the principle guiding visual identification as set out in the respondent state's relevant jurisprudence. The Court of Appeal examined these principles and the findings of the trial court and high court, and it was satisfied that there was no mistaken identity. Moreover, the record before this court shows that the police form 186 recording the conduct of the identification parade was tendered in evidence, and the police officer who conducted the identification parade, Deputy Sergeant Nu, also testified as prosecution witness 5 during the trial. In the view of this court, nothing on the record shows that the domestic court did not apply the law appropriately and in light of applicable standards. Both the High Court and the Court of Appeal examined the applicable principles governing the issue of identification and applied them to the evidence tendered in a manner that was fair and just. The Court finds that the respondent state did not violate the right to a fair trial with regard to the identification of the applicants. Second, application relating to the failure and delay in providing the applicants with some witness statements. The court recalls that in accordance with Article 7(1)(c) of the Charter, everyone has a right to defense. In criminal matters, this right requires that accused persons such as the applicant should be promptly informed of the evidence that will be tendered to support the charges against them, whether testimonial or in other forms, to enable them prepare the defense in this regard. The applicants should have been promptly provided with all copies of the prosecution witness statements to facilitate them to prepare the defense. The court notes that by the time the prosecution's case started on 28 August 2002, the respondent state had not provided the applicants some witness statements, and this continued up to 2.5 years later, despite the orders of the trial court in this regard. The court is of the view that this undue delay in providing the applicants with the witness statements affected the applicants' right to prepare the defense, which constitutes a violation of Article 7(1)(c) of the Charter. Consequently, the court orders that the denial of access to some of the prosecution's witness statements and the delay in providing them with some witness statements was a violation of Article 7(1)(c) of the Charter by the respondent state. 3. Allegation relating to the applicants not being given an opportunity to be represented by counsel. The court has previously held that the right to a fair trial under Article 7 of the Charter includes the right to free legal representation, especially in cases where accused persons are charged with serious criminal offenses that attract heavy sentences. The court has also previously held that for serious offenses such as armed robbery that carry heavy custodial sentences, the respondent state is under an obligation to provide the accused person, such as the applicants, pro motu and free of charge, the services of a lawyer throughout the judicial proceedings in the local courts. In the Eastern case, the applicants were charged with armed robbery, an offense that attracts a minimum sentence of 30 years imprisonment. The court therefore finds that by failing to provide the applicants with a lawyer to represent them in the proceedings, the respondent state violated the applicant's right to defense. Allegation that the court did not apply the required standard of proof. In line with its jurisprudence in the matter of Mohamed Abubakari versus United Republic of Tanzania, this court is of the view that a fair trial requires that where a person faces a heavy prison sentence, the finding that he or she is guilty and the conviction must be based on strong and credible evidence. In the Eastern case, the court notes that the trial court, the High Court, and the Court of Appeal determined that there was evidence to prove beyond reasonable doubt that the applicants committed the crime they were charged with, despite the fact that the weapon alleged to have been used to commit the crime was not tendered in evidence, and the owner of the bureau, the chain, did not testify. In the view of this court, there is nothing on the record to show that the domestic court did not apply the required standard of proof in convicting the applicants. In any event, the applicants have not provided sufficient evidence to show that the procedure followed by the domestic courts in addressing the issue of the weapon used to commit the crime and the testimony of owner of of owner of the Bureau de Change violated the right to a fair trial with respect to the standard of proof. Accordingly, the court finds that the respondent state did not violate the applicant's right to a fair trial in this regard. Allegation relating to the changing of the magistrates hearing the case. The issue for determination is whether to change the magistrate hearing the case affected the applicant's right to be heard. The court notes that the second indicates the record indicates that the case was heard by 3 different magistrates successively in 3 different instances. The first magistrate heard the matter until it was transferred to another duty station. The second magistrate continued hearing the matter until, following the applicant's complaints of loss of confidence in her, she recused herself from hearing the case. Therefore, the third magistrate completed the hearing of the case and delivered the judgment. The record also indicates that the High Court considered whether the second magistrate had proper grounds to recuse herself and whether the applicants were prejudiced when the second and third magistrates did not address the applicant's concern in terms of Section 214 of the Criminal Procedure Acts. The High Court examined the circumstances under which a judicial officer may be recused, namely that there should be evidence of a conflict between the litigant and the magistrate, or the latter has a close relationship with the adversary party or one of them, and that the magistrate or a family member has an interest in the outcome of the litigation other than the administration of justice. After examining these circumstances in light of the facts of the case, the High Court found that there was no justification for the second magistrate to have disqualified herself. Nonetheless, the High Court found that the failure of the second and third magistrate to address the accused in terms of Section 214 of the Criminal Procedure Act did not amount to an omission that would occasion injustice. The Court of Appeal also examined the issue and found that the trial court's failure to accord the applicants an opportunity to address it on whether the trial should have proceeded or started afresh did not constitute a fatal omission, as pursuant to Section 214 of the Criminal Procedure Act, the trial court had the discretion to proceed with the hearing without according the applicants this opportunity. The Court of Appeal found that the second and third magistrate who heard the case applied the discretion given to them under the law judicially. The court notes further that the applicants did not prove whether the magistrate were biased, whether the evidence admitted by the second magistrate was prejudicial to their case, or how the magistrates failed to properly apply their discretion by proceeding with the matter rather than hearing it afresh. In light of the foregoing, the court finds that the replacement of the magistrate in charge of the case does not violate the applicant's right to be tried by an impartial court. 6. Allegation relating to the lack of due consideration of written submissions by the Court of First Instance. The question for the court to determine is whether the applicant's right to be heard would be violated if their written submission had not reference to the judgment. The court is of the view that the right to be tried, to be heard, as provided, the right to be heard as provided under Article 7.1 of the Charter extends to the right to be given reasons for the decision. In the extant case, the record shows that the magistrate recorded the applicant's oral evidence, and after the close of the defense case, only the second applicant chose to file written submissions. The record also shows that the magistrate acknowledged receipt of the second applicant's written submission and that the prosecution chose to abandon the right of reply of the same. This court notes that the magistrate examined the evidence on record and provided a reasoned ruling On that basis, without having to make reference to the written submission. This quote further notes that record indicates that the lack of reference to the written submission did not form a ground of appeal before the High Court, but it was raised as a ground of appeal before the Court of Appeal. The Court finds that it has not been proven that the lack of consideration of the second applicant's written submissions violated the applicant's right to be heard. Accordingly, the Court holds that the respondent state did not violate Article 7.1 of the Charter. 7. Allegation relating to the judgment being defective and erroneous due to contradictory evidence and therefore being based on the wrong record. The Court finds that there is nothing on the record before it indicating that the domestic court did not comply with the provision of Article 7.1c of the Charter in assessing the evidence of this prosecution witness. Accordingly, the Court holds that the represented state did not violate Article 7.1c of the Charter. Allegation relating to misconstrued and misapplied evidence by the court. The Court notes that in the extant case, the applicants are making general claims regarding the violation of their rights without substantiation. Accordingly, the Court finds that the alleged violation have not been proven and therefore dismissed the same. Allegation that the 30-year sentence was not enforced at the time the robbery was committed. In view of the fact that the applicants abandoned this claim, the Court finds that this allegation has become moot. 10. Allegations relating to violation of Article 8 and 10 of the Universal Declaration of Human Rights. The provisions of Article 8 and 10 of the Declaration are reflected in Article 7 of the Charter, under the aegis of which the Court has already made determinations regarding some allegations of violation of the applicant's rights by the respondent states. In this regard, therefore, the Court finds that it's not necessary to determine whether the respondent has violated Articles 8 and 10 of the Universal Declaration of Human Rights. 11. Allegation that Section 142 of the Respondent States Evidence Act is incompatible with international standards on the right to a fair trial. The Court notes that national laws are considered as fact before international courts and can form the basis of allegations of violations of international law. The Court observes, however, that it does not appear from the above-mentioned provision that there is a restriction on cross-examination and accomplice. In any event, the applicants have not elaborated how the aforementioned provision of the Evidence Act does not conform to the international standards on the right to a fair trial. The Court therefore finds that this allegation lacks merit and consequently dismisses it. Allegation of violations of other rights. This Court notes that the applicants have not provided proof to support this allegation and nothing on record to indicate that the Court of Appeal rejected the application for review arbitrarily. This Court accordingly dismisses this allegation for lack of merit. Allegation relating to the rejection of the constitutional petition. The Court finds that this allegation lacks merit and consequently dismisses it. Allegation relating to violation of Article 2, 3, 5, 19 and 28 of the Charter and Article 1, 2, 5, 6 and 7 of the Universal Declaration of Human Rights. The Court finds that the alleged violations have not been substantiated and they are therefore dismissed. Allegation of violation of Article 1 of the Charter. The court recalls its previous decision in which it held that when the court finds that any of the rights, duties and freedoms set out in the Charter are curtailed, violated or not being achieved, this necessarily means that the obligation set out in the Article 1 of the Charter has not been complied with and has been violated. In the Eastern case, the court has held that the respondent state has violated Article 7(1)(c) of the Charter. On the basis of the foregoing observations, the court finds, in conclusion, that the violation of the said rights entails violation of Article 1 of the Charter. Remedy sought. Article 27(1) of the protocol provides that if the court finds that there has been violation of human people's rights, it should make appropriate orders to remedy the violation, including the payment of fair compensation or reparation. In this respect, Rule 63 of the rules provide that, and I quote, the court shall rule on the request for reparation submitted in accordance with Rule 34(5) of these rules by the same decision establishing the violation of human and people's rights, or if the circumstances so require, by a separate decision. As regards the applicant's prayer to be set free, the court has established that such a measure could be directly ordered by the court only in exceptional and compelling circumstances. In the Eastern case, the applicants have not indicated and provided proof of such circumstances. Consequently, the court dismisses this prayer. The court, however, notes that the aforesaid finding does not preclude the respondent state from considering such a measure on its own. The court notes that neither party made detailed submission concerning the other forms of reparation. It will therefore make a ruling on this question at a later stage in the procedure after having heard the parties. Cost. The court notes in this regard that Rule 30 of its rules provides that, I quote, unless otherwise decided by the court, each party shall bear its own cost. None of the parties have made a prayer as to cost. Having considered the circumstances of this case, the court decides that each party shall bear its own cost. For these reasons, the court unanimously on jurisdiction dismissed the objection to the jurisdiction of the court, declares that it has jurisdiction. On admissibility, dismisses the objections on the admissibility of the application, declares the application admissible. On the merits, finds that the applicants have not established the alleged violation of Articles 2, 3, 5, 19 and 28 of the Charter and Article 1, 2, 5, 6 and 7 of the Universal Declaration of Human Rights. Finds that the respondent state has not violated Article 7 of the Charter as regards the applicant's identification, the changing of the magistrate hearing the case, the alleged failure by the national courts to apply the required standard of proof, the alleged lack of consideration of the second applicant's written submission by the trial court, and the allegation that the judgments against the applicants were defective and erroneous. Consequently, finds that the prayer that the respondent state has violated Article 8 and 10 of the Universal Declaration of Human Rights has become moot. Finds that the incompatibility of Section 142 of the Evidence Act with the international standards on the right to a fair trial has not been established. Finds that the allegations relating to the dismissal of the applicant's application for review and the rejection of the constitutional petition have not been established. Finds that the respondent state has violated Article 7(1)(c) of the Charter as regards the failure to provide the applicants with free legal assistance, and the failure to provide the applicants with copies of some witness statements, and the delay in providing them some witness statements. Consequently, finds that the respondent state has violated Article 1 of the Charter. On remedies, does not grant the applicant's prayer for the court to directly order their release from prison without prejudice to the respondent states applying such a measure proprio motu, and allows the applicants, in accordance with Rule 63 of the rule, to file their written submission on the other forms of reparation within 30 days from the date of notification of this judgment, and the respondent state to file his response within 30 days from the date of receipt of the applicant's written submission. On cost, decides that each party shall bear their own costs. Done at Arusha, this 11th day of May in the year 2018, in English and French, the English text being authoritative. See the decision of the court. Read by Honorable Lady Justice Ben Saoula.
In the matter of Amiri Ramadhani, represented by Advocate Donald Leia, Pan-African Lawyers Union, versus United Republic of Tanzania, represented by Nisara Mwaipopo, Director, Division of Constitutional Affairs and Human Rights, Ambassador Irene Kasyanju, Director, Legal Affairs, Ministry of Foreign Affairs and International Cooperation, Ms. Nkasuri Sarah Kikia, Principal State Attorney, Mr. Mark Mulwambu, Principal State Attorney, Mr. Abubakar Mrisha, Senior State Attorney, Ms. Blandina Kasagama, Foreign Service Officer, Ministry of Foreign Affairs and International Cooperation. After deliberation, the court renders the following judgment. The parties, the applicant, Mr. Amiri Ramadhani, hereinafter referred to as the applicant, is a national of the United Republic of Tanzania who is serving a 30-year sentence in Ukonga Central Prison in Dar es Salaam for armed robbery, attempted suicide, and for inflicting grievous bodily harm on his person. The application is filed against the United Republic of Tanzania, hereinafter referred to as the respondent state, which became a party to the African Charter of Human and People's Rights, hereinafter referred to as the Charter, on 21 October 1986, and to the Protocol to the African Charter of Human and People's Rights, hereinafter referred to as the Protocol, on 10 February 2006. Furthermore, the respondent states on 29 March 2010 deposit the declaration prescribed in Article 34, Paragraph 6 of the Protocol accepting the jurisdiction of the court. Alleged violation. The applicant made several complaints in relation to the manner of his detention, trial, and sentencing by the respondent state's judicial authorities. Is especially complains about the following: having been accused on the basis of the biased acts of a police officer who, acting for and on behalf of the Criminal Investigation Department, obtained and registered in the applicant's statement in a manner contrary to the established procedure. Having been detained in contravention of the provision of Section 50 and 51 of the Criminal Procedure Act, having been sentenced on the basis of an error in law and in fact for having taken into account the so-called testimony of a prosecution witness, the excessive nature of the 30 years prison sentence pronounced by the court of first instance, contrary to the maximum sentence of 15 years set forth in Section 285 and 286 of the Penal Code, having been sentenced in violation of Section 13b(c) of the 1977 Constitution of the United Republic of Tanzania and contrary to the African Charter on Human and People's Rights, that the appellate court failed to take note that the 30 years prison sentence was excessive and was not applicable at the time the facts occurred, having not received the assistance of a lawyer as well as legal aid, having thus been discriminated against. That in light of the foregoing, the applicant submit that the respondent state has violated Article 13b and c of the Constitution of the United Republic of Tanzania, as well as Articles 1, 2, 3, 4, 6, and 7c and 2 of the African Charter on Human and People's Rights. The prayers of the parties. The applicant prayers as contained in the application are as follows. Facilitate him with free legal representation or legal aid under Rule 31 of the Rules of Court and Article 10, Paragraph 2 of the Protocol. Declare the application admissible and give effect thereto by invoking the admissibility conditions prescribed in Article 56 of the Charter, Article 6, Paragraph 2 of the Protocol, and Rule 40 of the Rules of Court. Declare that the respondent state has violated the applicant's rights granted by Article 1, 2, 3, 4, 5, 6, and 7, Paragraph C and 2 of the Charter. Consequently, issue an order compelling the respondent state to set free the applicant. Issue an order for reparation by virtue of Article 27, Paragraph 1 of the Protocol and Rule 34, Paragraph 5 of the Rules, and such order of leisure as the court may deem appropriate, should this honorable court find merit in the application and the prayer sought. Quash the conviction for armed robbery, the punishment inflicted, and release the application from prison. The applicant retained his prayers and sought the following orders from the court. A declaration that the application is admissible and that the court has jurisdiction to hear the case on the merits and per Article 3, Paragraph 2 of the Protocol and Rules 26, Paragraph 2 and 40, Paragraph 6 of its rules. A declaration that the respondent state has violated the applicant's right to a fair trial as protected by the Charter under Article 7 on at least 2 grounds. Failure to provide the applicant with legal assistance, convicting the applicant on the sole basis of a statement under caution that was uncorroborated and which the applicant had in any case withdrawn. The objection on material jurisdiction. The court dismissed the respondent state's objection in this regard and holds that it has material jurisdiction. Other aspect of jurisdiction. The court notes that it has personal jurisdiction, temporal jurisdiction, territorial jurisdiction. In light of the foregoing consideration, the court holds in conclusion that it has jurisdiction to hear the case. Admissibility of the application, condition of admissibility in contention between the parties. The respondent state raises two objections regarding the exhaustion of local remedies and the time frame for seizure of the court. Objection based on alleged non-exhaustion of local remedies. The court dismissed the objection based on the non-exhaustion of all local remedies proposed by the respondent state. Objection based on alleged non-compliance with a reasonable time. The court dismissed the objection relating to the non-compliance with the requirement of filing the application within a reasonable time and consequently finds application admissible. Condition of admissibility not in contention between the parties. The court finds that this application meets all the admissibility conditions set out in Article 56 of the Charter and Rule 40 of the Rules and declares the application admissible. On the merits, the applicant raises several claims that relate to the alleged violation of the right to a fair trial, allegation relating to the defective charge sheet, The court, relying on the report, holds that the allegation in respect of irregularities in the charge sheet is not established. The allegation relating to an error in law with regard to the testimony of prosecution witness is one. The court holds in conclusion that the allegation regarding procedural error relating to the statement of the prosecution witnesses E11 is unfounded. The allegation relating to the lack of legal assistance. The court finds that the respondent state was under an obligation to provide him automatically and free of charge the services of a lawyer throughout the judicial proceedings in the domestic court. Having failed to do so, the respondent state violated Article 7, Paragraph 1 and C of the Charter. The allegation that the 30 years prison sentence was not enforced at the time the fact occurred. The court holds that the allegation of a violation with regard to the punishment imposed of the applicant following this conviction for armed robbery is unfounded and as such dismissed the allegation. The allegation regarding the violation of Article 1 of the Charter. The court now holds that the respondent state has simultaneously violated its obligation under Article 1 of the Charter. Remedy so, the applicant raised inter alia that the court set aside his conviction, release him from prison and order that reparation measures be taken. As regards the applicant's prayer to be set free, the court has established that such a measure could be directly ordered by the court only in exceptional and compelling circumstances. In the instant case, the applicant has not set out such circumstances. Accordingly, the court dismisses this prayer. The court notes, however, that its decision does not prevent the respondent state from taking such a measure itself. The court lastly notes that the parties did not file submissions regarding other forms of reparation. Hence, the court shall rule on this issue at a later stage of the proceeding after hearing the parties. Cost. Considering the circumstances of this matter, the court decided that each party shall bear its own cost. For this reason, the court, unanimously on jurisdiction, dismisses the objection to the jurisdiction of the court, declares that it has jurisdiction. On admissibility, dismisses the objection on admissibility of the application, declares the application admissible. On the merits, find that the alleged violation of Article 7 relating to the irregularities in the charge sheet has not been established. Finds that the respondent state has not violated Article 7, Paragraph 1b of the Charter as regards the applicant's allegation of procedural error in respect of the statement of PV1. Finds that the respondent state has not violated Article 7, Paragraph 2 of the Charter as regards the applicability of the sentence at the time the robbery was committed. Finds, however, that the respondent state has violated Article 7, Paragraph 1c of the Charter as regards failure to provide the applicant with free legal assistance during the judicial proceeding and consequently finds that the respondent state has also violated Article 1 of the Charter, does not grant the applicant's prayer for the court to quash his conviction and sentence, does not grant the applicant's prayer for the court to directly order his release from prison without prejudice to the respondent state applying such a measure proprio motu, reserves its decision on the applicant's prayer on all the forms of reparation, decide that each party bears its own cost, allows the applicant in accordance with Rule 63 of its rules to file his written submission on the other forms of reparation within 30 days from the date of notification of the judgment, and the respondent state to file its response within 30 days from the date of receipt of the applicant's written submission. Signed by Sylvain Auré, President, Benkuko Vice President, Geraldine Geko, Judge, Hadji Gissé, Judge, Rafa Benachou, Judge, Angelo Matoussi, Judge, Nitiam Omenge, Judge, Marie-Thérèse Mukamudisa, Judge, Tuziman Chilumila, Judge, Shaki Kabensarga, Judge, and Robert Eno Registrar, done at Arusha this 11th day of May in the year 2018 in English and French, the English text being authorized. Thank you.
This is the decision of the court. The next one, Judge Maili Kemboge versus United Republic of Tanzania. The judgment will be read by Honorable Justice Matussi.
The court, composed of Silver Ore, President, Ben Kyogo, Vice President, Gerard Nyungeko, LG Gisi, Rafa Benashur, Anjou Matus, Tian Menge, Marie-Thérèse Mkamuliza, Tujilan Shizumila, and Shafika Ben-Saoula, judges, and Robert Eno, registrar. In the matter of Judge Maili Kemboge and United Republic of Tanzania. After deliberation, renders the following judgment. The parties. The application is filed by Mr. Judge Maili Kemboge, hereinafter referred to as the applicant, a citizen of the United Republic of Tanzania, who is currently serving a 30 years prison sentence at the Butimba Central Prison at Mwanza for the crime of rape of a minor. The respondent state is the United Republic of Tanzania. Subject of the application, factors of the matter. The records indicate that on 14 August 2006, in criminal case number 110/2006, before the District Court of Tarima, the applicant was convicted and sentenced to 30 years imprisonment, 12 strokes of the cane, and payment of a fine of 500 Tanzanian shillings for having committed the crime of rape of a girl of 15 years of age, an offense punishable under Section 130, subsection 1 and 2E, and Section 131, subsection 1 of the Tanzanian Penal Code, Chapter 16, as revised in 2002, hereinafter referred to as the Penal Code. The applicant filed criminal appeal number 85/2012 before the High Court of Tanzania, sitting at Mwanza, and criminal appeal number 327/2013 before the Court of Appeal of Tanzania, sitting at Mwanza. The High Court upheld the applicant's sentence on 13 September 2013, and this was affirmed by the Court of Appeal on 30th October 2014. Alleged violations. The applicant alleged that the following rights have been violated. The right to equal protection of the law provided under Article 3(2) of the Charter, the right to enjoy the best attainable state of physical and mental health provided under Article 16 of the Charter. I will skip the summary of procedure before the court and go straight to the prayers of the parties. Prayers of the parties. The applicant prays the court to restore justice by quashing the the conviction and sentence imposed on him and order his release. Grant him reparations for the violation of his rights and order such orders, measures, or remedies as the court may deem fit. The respondent state praised the court to declare that it has no jurisdiction to hear the matter and hear the application. The application has not met the admissibility condition. Find that it has not violated Article 3 and 7, 1C of the Charter. Rule that the applicant is not entitled to reparations. Dismiss the application for being unfounded. Order that the applicant pays the costs. Jurisdiction. In accordance with Article 39(1) of the rules, the court shall conduct preliminary examination of its jurisdiction. Objection to material jurisdiction. The respondent state raised objection to the jurisdiction of the court, claiming that by asking the court to re-examine the evidence adduced and examined by its courts, the applicant is requesting the court to sit as appellate court, for which this court has no jurisdiction. In this regard, the respondent state cites the court's decision in application number 001/2013, Ernest Francis Mtingwi versus Republic of Malawi. The applicant challenging the respondent state's claim asserts that the court has jurisdiction whenever there is a violation of the provision of the Charter and other relevant human rights instruments, to review the judgment passed by the domestic courts, re-examine the evidence, quash the sentence, and acquit him. To this end, the applicant cites the court's judgment in application number 005/2013, Alex Thomas versus Republic of Tanzania. This court reiterates its position as affirmed in Ernest Mtingwi versus Malawi, that it is not an appeal court with respect to decision rendered by national courts. However, as it underscored in its judgment of 20 November 2015 in Alex Thomas versus the Republic of Tanzania, this situation does not preclude it from examining whether the procedures before national court are in accordance with international standards set out in the Charter or other applicable human rights instruments to which the respondent state is a party. In the instant case, the applicant alleges violations of the rights protected by the Charter. The court accordingly has jurisdiction to determine whether the domestic court's proceedings that form the basis of the application before this court has been conducted in accordance with the international standard set out in the Charter. In view of the foregoing, the court dismisses the respondent state's objection that the court is acting as an appellate court and finds that it has material jurisdiction to hear the matter. Other aspects of jurisdiction. The court notes that the personal, temporal, and territorial jurisdiction has not been contested by the respondent state, and nothing in the pleadings indicates that the court does not have jurisdiction. From the foregoing, the court finds that it has jurisdiction to hear the instant case. Admissibility of the application. In terms of Article 6 of the protocol, the court shall rule on the admissibility of cases taking into account the provisions of Article 56 of the Charter. Pursuant to Article 39(1) of the rules, the court shall conduct preliminary examination of the admissibility of the application in accordance with Articles 50 and 56 of the Charter and Rules 40 of these rules. The court notes that the respondent state raises only one objection to the admissibility of the application, that is objection in relation to the requirement of exhaustion of local remedies. Conditions of admissibility in contention between the parties. The objection based on the exhaustion of local remedies. The respondent state contends that the applicant does not exhaust local remedies with regards to the alleged violation of the right to equal protection of the law and the right to legal assistance. According to the respondent state, these alleged violations are being raised before the court for the first time. In its reply, the applicant reiterates that he has exhausted all local remedies. He claims that with respect to the constitutional petition, the judge of the High Court could never make a ruling which would be at variance with the judgment rendered by a bench of judges of the Court of Appeal. With regard to the respondent state's allegation on legal aid, the applicant submits that the legal aid sought is that provided for in Rule 31 of the rules. The court notes that the applicant filed an appeal and had access to the highest court of the respondent state, namely the Court of Appeal, with the prayer to adjudicate on the various allegations, especially those regarding violations of the right to a fair trial. Concerning the possibility of filing a constitutional petition, the court has previously stated that this remedy in the Tanzanian judicial system is an extraordinary remedy that the applicant is not required to exhaust. Regarding the objection of the respondent state that the issue of legal aid was being raised in this court for the first time, the court holds that the said objection is no longer an issue because, according to the applicant, the legal assistance he referred to in this application was not in relation to the domestic proceedings, but rather a request to this court to grant him legal aid in accordance with Rule 31 of the rules. Accordingly, the court finds that the applicant exhausted local remedies as envisaged under Rule 45 of the rules. The court therefore dismisses this preliminary objection to the admissibility of the application. The other conditions under Rule 40 of the rules are not in contention between the parties. For its part, the court notes that nothing on the record suggests that these conditions have not been met in the instant case. The court therefore holds that the requirements are fulfilled. In light of the foregoing, the court finds that the instant application fulfills all admissibility conditions set out in Rule 40 of the rules and accordingly declares the same admissible. The merits. Alleged violation of the right to equal protection of the law. The applicant states that the judgment of the Court of Appeal was obtained by overlooking the court records and prejudiced his defense. The applicant alleged further that 2 of the 3 grounds of appeal were not considered by the Court of Appeal because that court found that the applicant did not raise them in his appeal before the High Court. The applicant claims that by overlooking the grounds in question, the Court of Appeal has confirmed itself only to procedural matter rather than considering the interest of justice. Accordingly, Accordingly, the applicant alleged that his right to equal protection of the law provided under Article 3(2) of the Charter has been violated. In his reply, the applicant refutes the contention of the respondent state that he confers to having committed the crime and insists that he has always pleaded not guilty. He also claims that before the domestic courts, the issue should have been about the marriage between him and the victim rather than the crime of rape, since he was living with the victim in a marital relationship. The respondent state refutes the applicant's argument that the Court of Appeal did not examine his contention regarding the victim's age and the mother's consent. It submits that the Court of Appeal did not take the contentions into consideration because it never considered them relevant for the reasons that the applicant has himself admitted having had sexual intercourse with a minor, and that the said arguments have not been raised before the High Court. The respondent state also submits that the issue requiring determination is the age of the victim. Having been proven that the victim was 16 years old, it remained to be ascertained whether, during the time she lived with the applicant, they had intercourse. According to the respondent state, however, the applicant himself confessed and confirmed the victim's statement that they had intercourse, sexual intercourse, at least once during the time they lived together in the applicant's home. The respondent state alleged that not only did the applicant confess to sexual intercourse with the victim, but also that during cross-examination, the applicant did not interrogate the victim on the issue of the age and the alleged sexual intercourse. According to the respondent state, the silence amounts to tacit acceptance of the